Now, next section for our discussion is section 17, change in name. Now, can there be a change in the name of the LLP? The answer to that is yes. If the central government passes an order, okay, against the LLP that they are required to undergo a change of name, that could be because it believes it to be undesirable after it has got incorporated, or it happens to be it is too identical, or maybe a registered trademark has made an application to the central government about this problem. Then in that case, obviously, central government will pass an order against the LLP that yes, the name has to undergo a change. Okay, in that case, LLP has no option. They have to change the name and inform the same to whom? ROC. Okay, simple points here. Same like Companies Act. The central government may direct LLP to change its name if it is undesirable to the central government or identical or too nearly resembles to that of an other partnership firm or LLP or body corporate or a trademark. LLP shall comply with the directions within how many months? 3 months after date of direction. But understand, very importantly, we have studied this in Companies Act also. But there, for trademark, he has to give an application, which has to give within 2 years. Correct? And there you have to have OR, past, and all of those things are there. Here it is LLP, OR, SR concepts are not there. So here they have to compulsory change the name within how many days? 3 months. Okay, then. Where an LLP changes its name or obtains new name, it shall within a period of 15 days from the date of such change give a notice of change along with the order of central government, who shall carry out necessary changes in the certificate of incorporation. And within 30 days of such change in the certificate of incorporation, such LLP shall change its name in the LLP agreement also. Okay. So you have to 15 days, you have to inform whom? ROC. ROC will make the changes within 30 days. And this same has to be incorporated where? In the LLP agreement. Okay. Something very similar. We have already studied this as a part of Companies Act. If the LLP is in default in complying with any of the directions given by the central government, okay, then central government shall allot a new name to the LLP, and the registrar shall enter the name in the register of LLP in the place of the old name and issue a fresh certificate of incorporation. Again, same like companies, central government has passed an order that LLP has to change the name. LLP is not doing that within the given timeline, that is 3 months period. In that case, central government obviously will now what they'll do. They will allot a new name to the LLP. And that name will be informed to whom? ROC. And ROC will issue a fresh certificate of incorporation with the name allotted by whom? Central government. So that is the seriousness behind this. Okay. So don't expect that if you don't do, central government will give you extension and all of those things. Very simple procedure they have taken up, they will give you the name. Okay. So that's the understanding. Provided that nothing contained in this section shall prevent the LLP from subsequently changing the name. Again, same like companies. First, central government will allot the name, but then can you still go and alter the name clause? Yes. So here also you can do the alteration. Eligibility to be a partner, 2 possibilities of becoming a partner to LLP. One, you sign on the incorporation document. So as soon as you're the member, as soon as the LLP incorporates, you will become the partner. Or later, if you want to become a partner, you have to become through the agreement. That is as per the terms given in the agreement. On incorporation of the LLP, the persons who subscribe their names to the incorporation document shall be its partners, and any other person may become a partner of LLP by and in accordance with the LLP agreement. So whatever terms are given of capital contribution, all of those things you have to fulfill, and based on that, you can become the partner in LLP. So everything will be given where? In the agreement only. Clear? All right. Then, relationship amongst the partners. Very simple. Mutual rights and duties will be decided based on the agreement. If agreement is silent, then the first schedule will come into picture where mutual rights and duties will be decided. Clear? Same as otherwise provided by this Act, the mutual rights and duties of the partners of the LLP and the mutual rights and duties of the LLP and the partners shall be governed by the LLP agreement between the partners or between LLP and the partners. I told you in this concept you have 2 agreements. One amongst the partners, one LLP and the partners. The LLP agreement and any changes, if any, made therein shall be filed with the registrar in such form and manner accompanied with such fees as may be prescribed. So agreement is going to be with whom? ROC. And if you make changes in the agreement, that also will be filed with whom? ROC. An agreement in writing made before the incorporation of LLP between the persons who subscribe their names to the incorporation document may impose obligation on the LLP, provided such agreement is ratified by all the partners after the incorporation of LLP. What does this mean? Suppose before the LLP is incorporated, there are some 4-5 people who have decided to form the LLP. So before the LLP is incorporated only, they met at one particular place and they had some terms and conditions decided among themselves. And they say, okay, this is going to be our agreement. Now tell me, suppose on incorporation, if these 5 alone are not the partners, but there are 10 partners. So this agreement which was decided by these 5 partners before incorporation, will it be binding on the LLP together, all the partners? No. When will it be binding? Only if it is ratified by all the partners after incorporation. That is the remaining 5 also. If they accept this document or accept this agreement after incorporation, then only the agreement made by them earlier will be binding on the LLP agreement. Otherwise, new agreement only will be made. Okay. So if some of them decide before the incorporation about some terms and conditions, these terms and conditions will be imposed on or will be an obligation to the LLP only if after incorporation, every single partner agrees to these things. Okay. Then last point you already know. In the absence of agreement as to any matter regarding the mutual rights and duties amongst the partners or between the partner and the LLP, then the provisions relating to the first schedule will be prevailing there. Okay, the first schedule will talk about that. In the absence of partner agreement between these 2 agreements, if they're not there or any provision is missing, then you have to refer to first schedule. Clear? All right. Then after that, we have cessation of partnership interest. You can mark it important for exam. Okay, now we know that if you want to become a partner in the LLP, it is as per the agreement. Cessation terms also will be given in the agreement. So look at the cessation terms, what they are, how many days notice you have to give, what should be the criteria, everything. That will be given in the agreement. But if agreement is silent, then act will come into picture. So look at that. A person may cease to be a partner of the LLP in accordance with what? Agreement. So what is given in the agreement, you do that. If in agreement they're telling you, you have to give 4 months notice before you leave. You have to give how much? 4 months notice only. Okay, then. With the other partners or in the absence of agreement with the other partners as to cessation of being a partner by giving a notice in writing of not less than 30 days to the other partners of his intention to resign from the partnership. Meaning is, if an agreement 4 months is given, 4 months only you have to follow. But if the agreement is not giving anything about resignation, then Act is telling you have to give minimum 30 days written notice to all the other partners. That is the understanding. When can a person cease to be a partner? On his death or dissolution of the LLP. On death, obviously, he cannot continue. Dissolution of LLP means all partners are leaving anyway. If he is declared to be unsound mind by the competent court, remember, in the beginning, disqualification to become a partner. In that case, first was what? Unsound mind. So now if you're declared as unsound mind, automatically you're disqualified. Third also we have discussed. If he's applied for adjudicating as insolvent or is already declared as insolvent, in both the cases, will you be allowed to be a partner? No. At that point in time, you'll become what? Discharged. I mean, you'll be disqualified to become the partner. So the moment you're unsound or the moment you're filing a petition for adjudicating you as insolvent or you're already undischarged insolvent, declared insolvent, then in that case, you will cease to be a partner in the LLP. Along with your death, dissolution of LLP, all of that criteria. Where a person has ceased to be a partner of the LLP, herein referred as a former partner. So retiring partner we call here to be former partner. The former partner is to be regarded as still being a partner of the LLP unless the person has the notice that the former partner has ceased to be the partner of LLP or notice that the former partner has ceased to be a partner of LLP has been delivered to ROC. Simple it is. Understand the partnership by estoppel, partner by holding out. Understand in partnership, you're required to give a public notice and only then you're considered to be no more liable. If you're an active partner, you're considered active partner only is not there. So every partner is equally responsible to participate. So here they're telling, look, to the third party, you will not be responsible if the third party knows that you are not a partner. So he has the notice of you not being a partner. Then you will not be responsible because you don't become partner by holding out. Or you give your cessation information to whom? ROC. When you give it to the registrar, it automatically becomes what? Public document. So if the partner with the person with whom you're dealing knows about you not being a partner, then you will not be responsible. Or you have informed ROC, then you will not be responsible. Otherwise, in that case, you will stand in the position of a partner by holding out and you will still continue to be liable even if you have retired from the LLP. Is it logically understandable? Yes. Then, meaning is if you leave, inform. At least the person dealing with should be knowing about it or inform ROC, everybody knows about it. Either of the things you don't do, you will still continue to be liable to the third party because you'll be considered to be partner by holding out here. Clear? Okay, then. The cessation of partner from LLP does not by itself discharge the partner from any obligation of the LLP or to the other partners or to any other person which was incurred while he was a partner. So retirement from the LLP cannot be an escape route for you. You can't run away from the liabilities telling, okay, I'm going by. That cannot happen. Meaning is, till the time of retirement, whatever has happened, you will continue to be liable even after you leave. So suppose on 31st of March, you're retiring. Whatever has happened up to 31st of March, You will continue to be liable till the things are all settled. Okay, obviously limitation to your liability is there. Where a partner of the LLP ceases to be a partner, unless otherwise provided in the LLP agreement, the former partner or the person entitled to his share in the consequence of his death or insolvency of the former partner. See, understand, if you are dying, legal representative, if you're declared as insolvent, your official assignee, or if you're just leaving, resignation, that means you. So either you or LR or official assignee, anybody, shall be entitled to receive from the LLP. What all will they receive? Obviously, think his share of capital, his profit share, everything. An amount equal to the capital contribution of the partner formally actually made. His right to the share in the accumulated profits of the LLP, that is reserves he has a share. After deduction of accumulated losses of the LLP, determined as the date of former partner ceased to be a partner. Nothing very complicated here. If I am a partner of the LLP and if I'm leaving, will I go empty-handed? No. What I want, what I bought, you give me back. So give my capital contribution. Second, all these periods we have earned the profit together, we are required to share the profits. So some profit we have withdrawn, but some profit is there in the reserves. So my share of the reserve I want. But during the year, there were losses. So we have decided to share the profits and losses. So if there has been an accumulated losses, then from the reserve, you minus the loss. And then whatever remains, give my share to me. I want the share, I don't want the complete one. So my share in the profit after adjusting losses. Along with that, I also require the capital which I've contributed. In capital, you don't use the word share because what you have contributed, you'll get it back. But reserves is a share of every partner. So you will get only your share. So the language has to be understood. Capital contribution and share from the profits after deducting all the losses. Clear? All right. Then a former partner or a person entitled to his share in the consequences of death or insolvency of the former partner shall not have any right to interfere in the management of LLP. Obviously. If you're leaving, how will you have the right of, even if you're standing as a partner by holding out because you have not given notice and all that, then in that case also, you will still be only responsible for all the decisions taken. Can you interfere into the management? The answer is no. So cessation point you have to remember properly. If an agreement is given, follow the agreement. If not, 30 days notice has to be given. You can leave on your death, that is automatically you leave, dissolution, insolvency, or unsound mind. Then you have to give notice either to the person with your dealing or to the registrar. If not, you'll continue to be liable. If you leave even then, up to the date of your retirement, you will still be liable for everything that has happened during the course. You or your LR or your official assignee, whoever the situation is, will be entitled to receive the capital contribution made by you and the share from the reserves. And also understand, you will have absolutely no right now to interfere into the management of the LLP because you're no longer a partner. Very logical. Clear? All right. Now, registration of change in partners. Can there be a change in partners? Yes. Okay, that means suppose the name of the partner is changing, address of the partner is changing, and very common it is. For example, especially in the case of a partner who's a woman, there could be a change in the surname. So don't you think changes have to be intimated? Yes. So understand they'll be intimating it to the LLP. LLP will inform it to whom? ROC. Partner directly has no contact with the registrar. Partner will inform whom? LLP. LLP has to inform whom? ROC. Similarly, if there is admission and retirement, then in that case, that also is a change in partners? Yes. So in this case, obviously, partner will not inform the LLP because partner is never going to tell the LLP, look, I'm retiring and all, LLP knows about it. So in that case, we don't require partner telling LLP, LLP telling ROC. No. If there is admission, retirement, death and all, then in that case, LLP is responsible to tell it to whom? ROC. But if there is a change in name, address and anything of a partner, then partner has to inform whom? LLP. LLP will then inform whom? ROC. So two changes we discuss here. Change in the personal details and change in the constitution. Both are covered. Okay. Registration of changes in partners. Every partner shall inform the LLP of any change in his name or address within a period of 15 days of such change. So you write there partner to LLP, LLP to ROC. Okay. And partner should inform within how many days? 15 days. LLP shall, where a person becomes or ceases to be a partner, that means admission or retirement, file a notice with the registrar within 30 days from the date he becomes or ceases to be a partner. So now tell me, when they're talking about admission and retirement, are they telling partner has to inform LLP and LLP to ROC? No. Directly they put the obligation on whom? LLP. So LLP shall, at the time when there is an admission or there is a cessation of partner, should inform ROC within 30 days. Where there is a change in the name of or the address, then file the notice with registrar within 30 days of such change. A notice filed with the registrar under subsection 2 shall be in such form and accompanied by such fees as may be prescribed, shall be signed by designated partners of the LLP and authenticated in the manner as may be prescribed. These are all legal compliances. So in that case, who has to sign these documents? Designated partners. If it relates to incoming partner, shall contain a statement by such partner that he consents to become a partner, signed by him and authenticated by him in the prescribed manner. So understand here they're telling name change, address change, partner coming in, partner going out. If out of the four, one is partner coming in, then along with this certificate, along with this form you're filing with ROC, you also have to give a written consent given by the incoming partner that is willing to be a partner. Okay, that also has to go to ROC. If LLP contravenes the provisions, punishment is there. If a partner contravenes, punishment is there. Partner contravenes means what? Partner has not informed about the name change, address change within 15 days. So your partner also has a responsibility. So if partner is not doing it, partner will be punished. And if LLP is not informing ROC within 30 days, either of admission, retirement, or this change intimated by the partners, then in that case, they'll be also punished. So here two different punishments are there. One for the partners failing to inform LLP. Second, LLP failing to inform ROC. Two set of punishments are given here. Any person who ceases to be a partner of LLP may himself file with registrar the notice referred to in subsection 3. If he has a reasonable cause to believe that LLP may not file the notice with the registrar, and in case of any such notice filed by the partner, the registrar shall obtain confirmation to this effect from the LLP, unless LLP has also filed such notice. However, where no confirmation is given by LLP within 15 days, the registrar shall register the notice made by the person ceasing to be the partner under this section. Very simple it is. Tell me, if it is not informed to the ROC about the resignation, who will fall in trouble? Partner will fall in trouble. Why? Partner will stand in the position of partner by holding out, and he will continue to be liable to the people. So because of that, partner believes, okay, LLP is not filing it, and I don't even think they're going to file it on the due time. So in that case, what partner will do? They are not filing, I will file it. So law says you're allowed. You can go and file with the ROC, no problem. But now you tell me the ROC is working for the partner or for the LLP? LLP. So don't you think without asking the LLP, will they directly register the resignation? No. So what they will do, once you get information coming from the partner, it has to go to whom? ROC. ROC is going to then send an intimation to whom? LLP. Look, we have got a letter like this. Should we register this change or not? If LLP responds, then they will not register it. Or LLP also has filed the registration, then obviously do it. But suppose 15 days, no reply coming from the LLP. Then in that case, what they will do? Listen to the partner and register the same. Same thing we do in registration of charges, you remember. Charge holder can also register the charge. But company will, ROC will still send intimation to the company. If company does not reply within 14 days, then they will consider to be accepted and register the charge. Remember all this, same concept here. So here also intimation has to be given by the LLP prima facie. If they don't, partner can give. But partner, when it gives, ROC has to inform the LLP. LLP has to respond back. If not, 15 days no action taken, then they will inform it, then register it. Clear? All right. Next points are very simple. Extent and limitation of liability of LLP and partners, we know it. Partner is acting as an agent of whom? LLP, not the other partners. All the acts done of the partner. Just give me one second. We'll take the remaining in the next clip.